Hello and welcome to the Ask About Wealth podcast. Today I'm delighted to welcome Jacquelyn Dunne. Jacquelyn is from Dunne Solicitors and the founder and creator of The Journey. Jacquelyn, thanks for coming along today.
I'm
delighted
so
to meet you.
For having me. And as you said, when I met you, you feel you know me.
I do.
Well, I feel I know you
I've
from
been
Instagram.
looking at your videos. A fellow social media content creator, I should have said. Jacquelyn, as we were talking just before we started to record here, in the broad financial planning sense, I see financial planning as having two major issues to deal with. Dying too young is the first issue and living too long is the second issue. Mm-hmm. And today we're going to focus on the first one, I think, because that's your focus. But I also shared with you a statistic we read recently, I think it was from King's Inn, which said only 27% of Irish adults have a will. Can you tell us why people should have a will?
Okay, well, if you don't have a will, first of all, it is the intestacy laws will determine where your estate goes. And when I say your estate, I mean all your assets, so your bricks and mortar and your cash assets. And that is fine if that's the way you want it to go. So, for example, if you are not married, you don't have any kids, and your parents are still alive, the intestacy laws say that your parents will inherit everything. If your parents have predeceased you, your siblings will inherit everything. If you are married, well then your spouse trumps your parents and your siblings. Your spouse inherits everything. But if you have children with that spouse, then your spouse only inherits 2/3 of everything and 1/3 goes to your children. And where I find it a big issue is this, I suppose because I'm a rural practice, I'd have a lot of farmers. So I'm dealing with a lot of farmers who, now that tends to be more often than not where they're transferring the farm to the son. And because of the young trained farmers exemption from stamp duty, the farm has to be transferred to the son before he turns 35 to avoid that big stamp duty bill so that they can claim that exemption. So you've got young boys who are but being gifted a very valuable asset. And then they go on to get married and they have kids and they're thinking, I'm too young to have a will. They don't even think about it. They're so busy on the farm. And I keep telling them, if you die in the morning, 2/3 of the farm is going to go to the wife, but 1/3 is going to go to the children. And with farms, a lot of farmers, I find, a lot of my clients, they don't want the farm to go to all their children.
To multiple beneficiaries.
Exactly, because then it's not going to be viable. They want it to pass on to the one child who is going to be the caretaker of the farm for their lifetime. Then it will pass on to the next generation. That's now if it's a working farm. And I keep saying, if you don't have that will, well then you're 2/3 to the wife, 1/3 to the kids.
That's a problem because it forces your spouse in that example into partnership with their children. That means that when the children reach the age of majority, they can start to look for their money. So they can force the surviving spouse in that case to buy them out or give them the value. Mm-hmm. Yeah. So it's not only that the wishes of the farmer in your example aren't carried out, but it could be accelerating the breakup of this farm. Because the children become the age of majority and demand their money.
Exactly. And I know from the farmers I have, that is definitely not what they'd want. So that's why it's important to make a will. It's the intestacy laws. I had a young girl, actually. She was the youngest person I ever had come into me to do a will. She was only in her early 20s and she had about 20,000. That was all. She had no house or anything. She had her car and about 20,000. But as I said to somebody else, that was 19,000 more than I had now when I was in my early 20s. But she came to me to do a will and I said, how is it that it's even crossed your mind? And she said, because I'm aware of the intestacy laws and I know that if I die, my parents will get it. And it's not that I have an issue with my parents, but I want my brother and sister to inherit that.
Yes.
And that is why it was important for me to do a will. So the will gives you the control.
The will allows you to express your wishes and for the most part have those wishes carried out.
Exactly.
Okay. It is also true to say that, isn't it, that while there are statutory requirements around wills in terms of spousal interests, for example, there are some I talk to people regularly and talk to them about the potential for a will to be challenged into the future because of the, I think it's Section 117, isn't it, of the Succession Act, which basically says, if I'm right, and you can correct me if I'm not, that parents must make proper provision for each of their children. So go back to that example you were using where the farm is going to one son and the rest of the kids are getting nothing. They have a right, don't they, to challenge that?
They do, but if you go back to my example, that son was not inheriting the land. He was
being
gifted the land. So by the time that father or the mother passes away, there is no farmland.
And is there's no ability for the disadvantaged siblings in that example to say, well, I know we got equal of the will, but your man got the farm 10 years ago. Is there a look back in that sense?
They could, yes, because when you look at a will, you look at, well, what did they receive during their lifetime? Exactly, yeah. But so if I'm doing a will, a contesting at the moment, where there is the father left the farmland to a son who he wasn't working on the farm. This son has a full-time job, and he left a china set to the daughter. And she is contesting.
She's less than happy.
She is less than happy with her china set. And she would have looked after her father in his later years and feels very hard done by. And she's bringing a claim under Section 117. But Section 117 is clear. A parent is not obliged to leave their estate equally to their children. You have to prove that he owed you a moral duty, that he owed her a moral duty, and that he should have made proper provision for her on the basis that she was living with him, she looked after him, and she was of the belief that he would leave her more.
Yes.
Whether the case will be successful now, you'll have to have me back.
Yeah, I will.
Again, to let you know if it will.
We'll make sure we rebook you. And in terms of that process, and I know it's how long is a piece of string, but in your experience, if there is such a challenge, how much time does that challenge take? And a second question, what does that do to the people who are the original beneficiaries, in the sense of, they were supposed to get it, but their siblings have challenged it. So how long does it take, and what does it do to the person who was the original named beneficiary? Well,
it's frozen. So the whole entire estate is frozen while you're waiting for these proceedings, and it can take a couple of years.
Okay.
I had another one in Limerick Circuit Court, and then the judge decided how the estate was going to be divvied out. So it wasn't as per the will exactly. But it did. It tied it all up. So there were siblings who were not party to the proceedings. They were, let's say, innocent parties, and they could not take their benefit under the will until such times these proceedings.
So the whole thing is frozen.
The whole thing is frozen.
In that respect. And frozen meaning that you talked about maybe cash assets. So those assets are frozen. The farm is being farmed, I presume. You can, the person can cut the grass or milk the cows or...
Well, it's the executor. So the executor has to look after the estate and has to run it, and any income derived from the farm has to go into the estate.
Okay, so that can't be distributed either.
That can't be distributed either, yeah.
So there are plenty of good reasons to have a will, and you and I were talking about it earlier before the cameras started to roll, as it were, and you mentioned, and I wholeheartedly agree, I think one of the reasons people don't have a will is superstition. If I write it down, I'll die. Do you find that? And do you find it difficult then to convince people to do a will?
I've met clients even recently who were in their 90s and didn't have a will made. And I think it's easier to convince younger people, 40s, 50s, 60s, to make a will. I think once you reach your 70s or your 80s, it's more imminent. And what a lot of people that I've met when I used to do talks on wills, a lot of them would say to me, well, the reason I'm not doing it is I feel if I go in to you to make my will, I'm going to die the next day.
Yeah.
And that's the fear. But what I always say to them is, I can guarantee you, you will leave my office feeling so much lighter, because they know it's something they have to do, but they're burying their head in the sand. And every so often, a friend or a family member will die, and it rears its ugly head again, and they're again thinking about it, but they're putting it off and putting it off. And that's what causes family disputes then. Is that...
Yeah, because without mum's will or dad's will, the inevitable, what dad really wanted was, what mum really wanted was.
Exactly. Yeah.
And two people have two completely different views about what those parents wanted. So writing it down is of vital importance. Is there, in terms of putting a will in place, and in terms of how long does a will really last for? I mean, I would say to people, and especially the audience that we have, which would be the high income earners and the high wealth people of Ireland, that I tell them a will should be reviewed regularly. Would you agree with that? And if you do, how regularly would you recommend somebody reviews a will?
You should review it every time life circumstances change.
Yeah.
So if you've referred to a particular property or particular farmland in your will, and now all of a sudden that's sold, or you've gifted it to one of your family members, well, then you'll have to come back and change it. I had one in particular where the father did leave a particular asset to one son and left everything else to the other siblings. But he sold that through me. And I said, right, sit down, we need to change your will. And he kept saying, look, I don't know yet. And kept saying to him, if you die, you're essentially inheriting this son where you've sold it, because the rest of the siblings were getting the residue of the estate. And of course, the sale proceeds now went into the residue, which would mean this son who was getting that asset
is no longer getting
anything. Yes. Okay. So I kept saying to him, you're giving me sleepless nights. You need to come back here and do this will.
So
as
you
life
do
circumstances,
agree that major life events, major events should cause at least a review.
If you separate is another one, and what I tell my clients there's a lot of people in Ireland, they will separate, but they won't go down the route of a legal separation, or they won't go down the route of a divorce, because they're saying we don't want the cost of it. They go on their merry ways, and they may not see each other for 10, 20 years. But what I tell them is, if you don't change your will, so they might have a will from when the early years in their marriage where they had young kids, and a standard husband and wife will is that you leave everything to your spouse, you name them executor, but in the event that you're both gone, this is what we want to be left to the kids. And these clients that I have, they forget about their old will, and they go off on their merry way, they're separated from their spouse, and if they die, the executor... So if they die, their estate now goes to the spouse that they're separated from.
Yeah, because they didn't update the will.
Exactly. But let's say then they do update the will, and they leave it now. They're not leaving it to the spouse. They're leaving it to somebody else, or maybe they have a new partner, or maybe they want to leave it all to their children. I'll say to them at that stage, right, now you really need to go through for your legal separation. Let's at the very least, let's do just a separation agreement, because we'll put a little clause in it to say that your ex-spouse is not entitled to make any claim against your estate, against that will.
So the ex-spouse in that example is waiving their rights.
Exactly.
In that process.
Because if they don't, let's say then, fast forward 10 years' time, and this gentleman dies, and he's got his will, he changed his will, he did the right thing, he left everything to his children. The executor in that will is obliged to tell the ex-wife, even though he may not have seen her in the last 10 years, the executor is obliged to let that ex-spouse know that he is deceased, because she has to have the opportunity to come and claim something that's called the legal right share. And that's under Section 111 of the Succession Act. And where there are children, it is 1/3 of the estate. And where there are no children, it's half of the estate.
Oh, okay.
So she doesn't even have to go to court for that. So it's not like the Section 117.
It's not, there's no hassle factor to that.
No hassle factor. All she has to do is say to the executor, I'm claiming my legal right share. That's what I'm entitled to under the Act, even though she hasn't met him in the last 10 or 20 years.
Yeah. Okay, so
two things are important. Update your will when your life circumstances change, and if it is a thing you've separated, go get that separation agreement at the very least.
But of course, in that example of go get the separate, I mean, the spouse in question doesn't have to waive their rights, of course. That's a choice they would make, isn't it?
It is a choice, but I've never seen a separation agreement because likewise the spouse will be saying, well, I don't want him to come after my estate
or whatever,
exactly if I die. So
okay, so it usually is beneficial to both parties in that example. I mean, the way you're talking there, it reminds me, I remember reading about a gentleman called Warren Buffett, who you may be aware of, is I think the 8th richest man in the world or something like that. But I read Buffett said that every 2 years he rewrites his will and he brings his family together before he signs it, and he lets them read it.
Good, yeah.
So that gives them an opportunity to question why he's doing certain things. It gives them an opportunity to make suggestions, because he's in his late 80s. All his kids are in their 60s. You know, they're not babies. And I think for people with high value assets, that sounds sensible to me. When you talk to people with high value assets, do they involve the family at that time rather than it being a surprise down the line?
Yes, I can actually, I know of a good couple of clients where they do inform their children. Yeah. But they have good relationships with their children and their family, and their children in turn have good relationships with each other. But if you've got a situation where your children are not talking, that's a lot more of a difficult ask.
It'd be, as you say, it'd be a nice thing to do, but it may not be possible to do, because it shouldn't stop you trying. I mean, I often say to people that the way to get human beings to act as one is to find a common enemy. And you know, I would use the example of COVID. Look what happened with COVID. The Chinese are sharing information with the Americans, they're sharing information with the Russians. These guys are pointing nuclear missiles at each other all the time. But suddenly humanity has a common enemy and they're acting in unison. The common enemy often, in terms of succession, I would suggest, is the taxman. And that, you know, so, you know, I would often say to people that I meet on consults, you know, what is absolutely guaranteed is the maximum tax possible will be paid if you don't plan. And therefore bringing those people who might have opposing views, but they tend to all have the same view around the taxman, which is let's avoid it if it's possible and legitimate to do so. And that leads me to a question for you with your solicitor's hat on. Do you take tax into it? Somebody comes into you and says, I want to do X, Y, and Z. Is there ever a case where you go, actually, that's probably not a sensible thing to do because of tax?
Mm-hmm. Only recently I had a lady come in to me. She's not married. She doesn't have kids of her own. She has 6 nieces and nephews. She's very close to them. And one of them, she's a godmother to. So she was leaving nearly the entirety of her estate to this one godchild. But she said, I actually get on very well with all of them. They're all very good to me. And of course, the nieces and nephews fall into category B, as we know, which means that they can only inherit 40,000 tax-free, and anything over that was being taxed at 33%. So I said, right, let's try and work out a value of your estate currently. And if she had died in the morning, that nephew was going to be paying over 100,000 in tax. So we looked at what exemptions are out there, and she said, God, it's a no-brainer. I just leave it equally to all of them.
And no tax appears because they're all within the 40 grand.
They're all within the 40 grand. Now, she wanted to leave the godchild a little bit more, so she knew he'd be taxing it, but that was fine. That was the way to do it. And I said, by leaving it to all of them, you were making your estate, all this money and all this estate that you'd built up over your lifetime, rather than it going to the taxman when you die, you're making it as tax efficient as possible. So yeah, definitely. Another one is the agricultural relief. So you might have children who are not farmers and they're going to inherit the land. In those circumstances, they can claim an agricultural relief. So what we often do is when, let's say, the parent who was the farmer dies and he's leaving it to his children, all in equal shares, so we know it is eventually going to have to be sold, but they, for the moment, are going to become equal shareholders in this land. But, of course, land is extremely valuable and it pushes them over the tax-free threshold of 400,000 each. But what we do is we put a stop on it. We put a stop on applying for the grant of probate to allow us a time between the death and the grant of probate to get our affairs in order so that we can claim a thing called agricultural relief.
Okay.
The agricultural relief is 80%. If 80% of everything you own when you inherit the land, so you take the land that you're inheriting,
plus everything you
take
already
all
own.
your other assets, throw them into a jar, and if 80% of everything that's there is farmland, is agricultural, including now your dairy goat shares, your stock, your machinery, if at least 80% of everything there is agricultural, you can reduce the value now of your inheritance by 90%. But what you will find is that a lot of these sons or daughters, by the time their parent dies, they already have a house. And houses now are valued at so high, and that is reducing their non-farm asset.
Right.
So between the period of where the parent dies and getting the grant of probate, what we do is we transfer the house into the husband's name or the spouse's name.
Right.
So now you've reduced their non-farm asset. Now they pass the 80% test, and now we can apply for the grant of probate, and they can claim that relief.
So in that case, you're deliberately delaying probate, aren't you?
We're deliberately
for that
exactly.
type of, if you like, post-death planning.
Yes.
Very good, very good. And you know, taking modern families into consideration, I just want to ask you one more thing on the will side, and that's about stepchildren. I mean, I meet many people now on my consults who have, you know, this blended family. Mm-hmm. They're married to a spouse. They have 2 children together. They each have 1 child from previous relationships. Is there a difference? And I think I know the answer to this, but I'm going to ask it anyway for our audience. Is there a difference between the thresholds and tax-free thresholds that I can leave to my stepchildren versus my biological children? And secondly, is there a difference under that section 117 we spoke of, or another section, where those children, if they felt they hadn't been fairly treated, have or have not the ability to challenge under that?
So when you look at stepchildren, you have to look at 2 acts. One is the Succession Act, and the other is the Capital Acquisitions Tax. So under the Succession Act, there is no reference whatsoever to stepchildren. So to answer your question, do they have a right under that section 117? They don't. So if their step-parent didn't leave them anything, they have no right under that section 117 to make a claim, because there's no reference to stepchildren in the Succession Act.
Okay.
However, there is reference to stepchildren in the Capital Acquisitions Tax Act, which means if the step-parent wants to leave their stepchild something, they are treated the same as though they are the biological children, and they have the €400,000 tax-free threshold.
Okay, so in that case, if I can throw an example at you, you've got a couple who are married. They each have 2 children from a previous relationship, so they each have 2 stepchildren and 2 biological children. And one partner dies, and their estate leaves to their spouse. Now that spouse is left with 2 stepchildren and 2 biological children. If that spouse changed their will at that stage and only left the money to their biological children, am I right in thinking what you've just said means those stepchildren have no ability?
It. Yeah, exactly. I recently met a couple exactly like that, where they were both previously married. They both have children of their own. Now, they don't have children in common, but they have a house that they own jointly. So the solicitor, when the solicitor bought this house for them, they both had their money coming in to buy it, and they were both paying the mortgage, and the mortgage is cleared now. They both own it jointly, which means that when one of them die, it automatically goes to the survivor of them, regardless of what's in their will.
Yes.
And what I said
to them, joint ownership.
Because of the joint tenancy. What I said to them is, now, so let's say one of them dies, let's say she dies, and now he is the sole owner of the house, and the house is their main asset. The house is worth nearly $1 million. He is quite entitled to do a will leaving it to his children and disinherit her children. And they were saying, well, what do we do about this? And I said, well, what we do is we change your registration of the house from joint tenancy to tenancy in common. So the difference between joint tenancy and tenancy in common is joint tenancy is when one of them dies, the surviving joint tenant automatically takes all, regardless of what's in the will. Let's say they had a falling out and she did a will leaving her half share of the house to Joe Bloggs. That part of the will fails. I always say it's like pouring my waddy into water. It becomes diluted, your ownership. But if you own the property as a tenant in common, now you can own a tenant in common 30%, 70%, 50%, 50%. So let's say in this case, we transfer their ownership to tenancy in common, where they own 50% slice each. That means that when we did a will then for each of them, saying that, well, when I die, I leave my half share of the house to my biological children, leaving a right of residence for my partner in it for his lifetime, and vice versa.
Right.
And so that protected their half share for their children.
And is that an easy process from one tenancy structure to another tenancy structure?
So it's a deed of transfer. So all I need is the LPT number, their PPS numbers, evaluation of the property, and then we change it that way.
Okay.
We have to go through the revenue system and then gets lodged in the land registry, yeah.
So it may take a time and it may cost a few bob, I suppose, but
a couple of €100.
Yeah, okay. So it's incidental cost and well worth it in that.
For them, it was a peace of mind, 100%, because they both said to me, Asher, look, if something happened to me, that I know they'd look after my kids. Yeah. But you just never know.
Well,
they were still quite a relatively young couple. What if they met somebody else?
I knew, you remind me of a story of a fella client years ago who was married a second time and went to live overseas. And the lady he married was very wealthy. And he was reasonably wealthy, but she was considerably wealthier than him. And they had a verbal agreement, which was that neither would claim the 1/3 spousal minimum. You had a name for it there.
The legal right share.
Legal right share. But it was never in writing. And he did die, and she did claim the 1/3.
With all the money she had.
Yeah.
She
Even though, I often quote, there's a mantra, if it isn't in writing, it doesn't exist.
Yeah.
And I think what you've told me here is not only all the reasons why people should have a will, but there are nuances to the will based on individual circumstances, aren't there?
I had a colleague actually just talking about that couple, where this couple were on the doorsteps of the divorce courts, and they had done their new wills, leaving it because their old will had left everything to each other. So in contemplation of their divorce, they were leaving it then to their friends and neighbours, and he dropped dead about a week before the court hearing, and she claimed her legal right share.
Of course she did.
Now, they were objecting to it. She ended up having to go to court because they just were refusing to give it, and she got her legal right share.
Yeah.
Even though they were on the doorsteps of the divorce court.
Divorce, yeah. But if it isn't in writing, it doesn't
Exactly,
exist.
Yeah.
Okay. Well, thanks for that, Jacquelyn. I mean, I said at the start we'd talk about two things. We've talked about the dying too young bit, and just to explain to people, when I say that, I don't mean the person dying is too young. I mean that they're dying before a proper succession plan is put in place, that proper wills are put in place, the proper, division of assets, going back to the Buffett situation, that it's been discussed with the family, especially when we're talking about high value assets that we tend to talk about. But now let's move on to the journey. And this is more your social media hat. How I became aware of you was through your social media posts. Tell us about the journey. Tell us about how this came to be.
So I do a lot of probate. So I do a lot of wills. So I will meet you when you come to me to do your will, and then I meet your family when you die. And I could see the stress and the confusion for family members, because quite often they'd come to me and I'd say, right, we need to gather all the information on your late father's estate. Where did he bank and so on? And quite often they'll say, geez, I don't know. I'll try and gather as much information as I can from my client when they come and do a will with me. But of course, over the years, I've wills in my safe that are 20 years old.
Yeah. Things have changed.
Things have changed. They've purchased new assets. They've sold assets. And then there was a story that I had where I had a gentleman. Did I tell you this one about 42,000 already?
Yeah, but you're not.
I can't remember. Did I tell you in there?
You told
or did
me
I tell
that
you
before
here?
we were recording. So tell us again.
This is the tiredness. But I have a story where a previous client, where he was a widower. He had just bank accounts, a lot of cash assets. And when he died, the son came in to me and he said, look, here are the bank accounts that we know Dad has, but you might just make a check to make sure he didn't have any. So I did what I always do. I sent the letter to the bank with the death cert to say, here are the bank accounts we have, but we also carry out checks to make sure he doesn't have anything else. So that was fine. Done and dusted. The bank gave me the cert of balances. I applied for the grant of probate. With the grant of probate, we drew down the money from the bank accounts and we administered it in accordance with this gentleman's will. A couple of years later, the son calls me and he says, look, I was cleaning out under Dad's stairs and I'm after finding another bank statement. I'm not sure if there's any money in it, but you might want to deal with it. So I said, perfect. Called the bank and the bank apologised to me and they said, look, there's actually 42,000 in there. We're really sorry. It turns out that it went into a dormant account.
Behind the sofa.
Yeah, well, it had gone into a dormant account. So in Ireland, if you don't kind of lodge money to an account or withdraw money from an account, it goes into what's called a dormant account. And in Ireland, if it sits in that dormant account for 15 years, the bank are obliged to remit that to the NTMA, which is a government body. And this government body has millions of yours of your money in it. Now, they do use it for underprivileged areas. It's a very good cause. But this gentleman who had passed away, that was not his intention. So I'll always say to people, it's not enough for your family members to know where you bank. They need to know the bank account numbers, how many accounts you have in it. I had another case where a lady, she had went to her solicitor to do her will. She was a widow and she said to the solicitor before she left, she said, look, will you just take a note? I do not want to be buried with my late husband. I want to be buried in a different graveyard altogether with my parents. Anyway, fast forward a couple of years, this solicitor was visited by this lady's children. She'd just been buried and they wanted to know in the will, had their mother mentioned anything about money put aside for drinks and food for after the burial. And my colleague took out the will and then he looked at the notes and I said, oh, by the way, where was your mum buried? And it transpired she was buried with her husband, which was against her wishes. So quite often I'll have clients when they're doing a will with me and they'll want me to put down what their wishes are for their funeral. And I'll say, don't tell me you could be 6 foot under. You need to document this somewhere. So that's where I started coming up with the concept. I said, I need to find something that I can give clients when they're doing a will with me, that they can take it away, that I can say, fill this in, put it somewhere safe, let your loved ones and your executors know where it is so that when you pass, it's all there, all your information, there's no guesswork. Right. Couldn't find anything on the market. I could find an American book called I'm Dead Now What? And I said, I'm definitely not giving that to clients. And, it was copper fastened how important it was when I had another situation where a lady passed away. She said to her son, when the son called me, he said, look, Mum had always said her important information is in the sitting room. I have it here. Can I bring it out? You'll need it for the probate. I said, perfect. I'm here all day. Drop it out to me. And I remember opening the door to him and he had this crate that was just laden down with paperwork. And I just thought to myself, oh my God, this will literally take me hours to go through. And I took it off and I said, come on in. And he went, well, I actually have another one in the car. And I said to myself, oh, Lordy. But I felt so sorry for this lady because she knew how important it was to keep that information there. Yeah. But actually what she did was she just overwhelmed her children because I said, you couldn't afford for me to spend days looking through this. You're going to have to look through this. Yeah. And it was totally overwhelming. And the whole point then of the journey folder was that everything that was in those 2 crates can be put into this folder. So it's split into 3 parts. The first part deals with your passing. And as a solicitor, I know exactly what an executor needs to do. So there's a 9-step guide there for your executor. Step 9 lists all the documents and the information your solicitor will need. Because what I was finding was the probate process takes so long for solicitors because we're just waiting for all that information in. Yes. So I was trying to make it as easy as possible for the executors.
Of poor planning.
Exactly, and not letting family members know. And what I find a lot is clients will say, God, I'm going to buy the journey from Mum or Dad because I can't broach the subject with them about their finances because I don't want them. They'll tell me to mind my own business. Yeah. Well, at least I can say
they'll think you want them dead so you can get their money.
Exactly. Part 1 then goes on in-depth details about your funeral wishes. Part 2 deals with your incapacities. So let's say you got dementia or Alzheimer's. Just a list there about your enduring power of attorney, important information about you and your medical information. And then part 3 lists all your financial information. There's even a section there on what subscriptions need to be cancelled or accounts need to be closed, pets, loans you might have out with somebody, mortgages, everything is covered there. And so that is what the journey encapsulates.
So it's a way of you being ultra prepared, isn't it? By the sounds of that you're,
and it takes the guesswork out of it. Yeah. And I suppose as a solicitor,
there's what Mum really wanted was guesswork, as you say.
I had a local couple actually purchase one from me, and my husband had to pop over to them there one day. They're farmers, and he could see the book up on the kitchen table, and they said, "We're filling it out every evening. We love it." And I suppose I put so much work into making it look aesthetically beautiful, because it could be a little bit morbid thinking about it, but they loved having it out because it looks lovely to have it sitting there.
Show it to the camera there, and just so people can see what you're talking about.
But this particular man, he passed away. Quite suddenly. He was in his late 70s, and I was at the funeral and I was sympathising with the family. And when I was sympathising with his daughter, she said to me, "Have a look at Dad's coffin." And when I turned around, he was in a wicker coffin. And I said, "Oh God, a wicker." I said, "I've never seen one before." And she said, "Well, we would never have known that Dad wanted a wicker coffin only for your book, The Journey." And it opened up a line of discussion that we would never have gotten with Dad and Mum only for your book.
And when did you launch this, and how has it gone so far? And I suppose most importantly, how can people get The Journey?
Yeah. So it launched last October, so over a year ago. We've sold out of 2 shipments, and our largest shipment has just arrived. So a lot of them have been sold already on pre-order, which is amazing. You can go onto my website, thejourney.ie, and you can purchase it there. It's €150, inclusive of the VAT and inclusive of postage. It does come in fabulous packaging, if I may say so myself, and a lovely presentation box. A lot of my customers say they hold on to the presentation box actually and put some extra important information in it. But actually the folder has an inbuilt wallet, like the wallet that you'd have your notes in, because I prompt you throughout of what important documents you need to put in there.
You need to put in there, yeah. Well, look, Jacquelyn, I can't thank you enough for coming in. I'm delighted to meet you. As I said, as you said at the start, I think I know you before I met you. Congratulations on your content. I think it's fabulous. I think you're doing exactly in your space what we're trying to do, which is give people new knowledge and new information so they can make better decisions. And The Journey sounds to me like something that should almost be in every household, so that people gradually fill it in over time and cut out the guesswork. Jacquelyn Dunne, thanks very much for your time today.
Thank you so much for having me.